Module 4, Residency Cycle, Admission, Continued Residency, and Discharge Criteria. Purpose: teach trainees about admission, continued residency, and discharge criteria. Objectives: upon completion of this module, the trainees will be able to understanding of ALF resident admission criteria, identify the components of the admission package, promotional brochure, or copy of contract, demonstrate an understanding regarding a resident's health assessment requirements and timeframes, demonstrate an understanding of continued residency and exemptions. Demonstrate knowledge of the admission requirements for mental health residents. Demonstrate knowledge of the requirements for the involuntary examination, hospitalization for mental illness. Demonstrate knowledge regarding discharge criteria. Demonstrate knowledge regarding the contribution, solicitation, prohibition regarding residents supported by state funds. Demonstrate an understanding of the facility's responsibilities in the case of facility closure. Demonstrate an understanding of resident admission criteria. An individual must meet the following minimum criteria in order to be admitted to a facility holding a standard, limited nursing services, or limited mental health license. Be at least 18 years of age. Be free from signs of symptoms of diseases that is likely to be transmitted to other residents or staff. An individual who has HIV infected may be admitted to a facility provided that the individual would otherwise be eligible for admission according to this rule. Be able to perform the activities of daily living with supervision or assistance if necessary. Be able to transfer with assistance if necessary. The assistance of more than one person is permitted. Be capable of taking medication by either self-administration, assistance with self-administration, or administration of medication. The resident needs assistance with self-administration of medication. The facility must inform the resident of the professional qualifications of facility staff who will be providing this assistance. If unlicensed staff will be providing assistance with self-administration of medication, the facility must obtain written informed consent from the resident or the resident's surrogate, guardian, or attorney in fact. The facility may accept a registered administration of medication if the facility employs a nurse who will provide the service, or the resident or the resident's legal representative, designee, surrogate, guardian, or attorney in fact contracts with a third party license to provide this service to the resident. Not have any special dietary needs that cannot be met by the facility. Not be a danger to self or others as determined by a healthcare practitioner or a mental health practitioner. Not require 24-hour licensed professional mental health treatment. Not be bedridden unless the resident is receiving licensed hospice services. Not have any stage 3 or 4 pressure sores. A resident requiring care of a stage 2 pressure sore may be admitted provided that the resident either resides in a standard or limited nursing services licensed facility and contracts directly with the agency or a nurse to provide care, or resides in a limited nursing services licensed facility and care is provided by the facility pursuant to a plan of care issued by a health care practitioner. The condition is documented in the resident's record and admission and discharge logs, and if the resident's condition fails to improve within 30 days, as documented by a care practitioner, the resident must be discharged from the facility. Residents admitted to standard limited nursing services or limited mental health licensed facilities may not require nursing services. Artificial airway management of any kind, except that of continuous positive airway pressure, may be provided through the use of a CPAP or BiPAP machine. May not require any follow nursing services. Assistance with tube feeding. May not require any of the following nursing services. Monitoring of blood gases. May not require any of the following nursing services. Management of post-surgical drainage tubes and wound vacuum devices. May not require any of the following nursing services. The administration of blood products in the facility, or may not require any of the following nursing services. Treatment of surgical incisions or wounds, unless the surgical incisions or wound and the underlying condition have been stabilized and a plan of care has been developed. The plan of care must be maintained in the resident's record. In addition to nursing services listed above, residents admitted to facilities holding only standard and/or limited mental health license may not require any of the following nursing services: hemodialysis and peritoneal dialysis performed in the facility, intravenous therapy performed in the facility. Not require 24-hour nursing supervision unless the resident is receiving licensed hospice. Not require skilled rehabilitative services. Be appropriate for admission to the facility as determined by the facility administrator. The administrator must base the determination on an assessment of the strengths, needs, and preferences of the individual. The medical examination report. The facility's administrative policy service facility is prepared to provide or arrange in order to meet residents' needs Such services may not exceed the scope of the facility's license unless specified elsewhere in this rule, and the ability of the facility to meet the uniform fire safety standards for assisted living facilities, who otherwise meets the admission criteria for residency in a standard licensed facility, but who requires assistance with the administration and regulation of portable oxygen or assistance with routine colostomy care of stomacite flange placement may be admitted to a facility with a standard license as long as the facility has a nurse on staff or under contract to provide the assistance or to provide training to the resident on how to perform these functions themselves. Nursing staff may not provide training to unlicensed persons to perform skilled nursing services and may not delegate the nursing services described in this section to certified nursing assistants or unlicensed persons. This provision does not restrict a resident or a resident's representative from contracting with a third party to provide the assistance. If the facility is agreeable to such an arrangement and the resident otherwise meets the criteria for admission and continued residency is in a facility with a standard license. An individual enrolled in and receiving licensed hospice services may be admitted to an assisted living facility. Resident admission criteria for facilities holding an extended congregate care license. An individual must meet the following minimum criteria in order to receive extended congregate care services. Be at least 18 years of age. Be free from signs and symptoms of a communicable disease that is likely to be transmitted to other residents or staff. However, an individual who has HIV infected may be admitted to a facility provided that he or she would otherwise be eligible from admission according to this rule. Be able to transfer with assistance if necessary. The assistance of more than one individual is permitted. Not be a danger to self or others as determined by a healthcare practitioner or a mental health care practitioner. Not be bedridden unless the resident is receiving licensed hospice services. Not have any stage 3 or 4 pressure sores. Not require any of the following nursing services: artificial airway management of any kind, except that of continuous positive airway pressure, may be provided through the use of a CPAP or BiPAP machine. Nasogastric tube feeding, monitoring of blood gases, management of post-surgical drainage tubes or wound vacs, skilled rehabilitative services as described in Rule 59G-4.290, treatment of a surgical incision unless the surgical incision and the condition that caused it have been stabilized and a plan of care developed. The plan of care must be maintained in the resident's record at the facility. Not require 24-hour nursing supervision unless the resident is receiving licensed hospice services have been determined to be appropriate for admission to the facility by the facility admin. The administrator or manager must base his or her decisions on an assessment of the strengths, needs, and preferences of the individual, the health assessment, and the preliminary service plan. The facility's residency criteria and services offered or arranged for by the facility to meet residents' needs, and the ability of the facility to meet the Uniform Fire Safety Standards for assisted living facilities, notwithstanding any other provisions of this rule. An individual enrolled and receiving licensed hospice services may be admitted and receive extended congregate care services. Criteria for continued residency in the extended congregate care services must be the same as the criteria for admission, except as specified in the next slides. A resident may be bedridden for up to 14 consecutive days. A terminally ill resident who no longer meets the criteria for continue may continue to reside in the facility if the following conditions are met. The resident qualifies for, is admitted to, and consents to the services of a licensed hospice that coordinates and ensures the provision of any additional care and services that may be needed. Continued residency is agreeable to the resident and the facility. An interdisciplinary care plan which specifies the services being provided by hospice and those being provided by the facility is developed and implemented by a licensed hospice in consultation with the facility, and documentation of the requirements is maintained in the resident's file. The extended congregate care administrator or manager is responsible for monitoring the appropriateness of continued residency of a resident in extended congregate care services at all times. A hospice resident that meets the qualifications of continued residency may only receive services from the assisted living facility staff within the scopes of the facility's license. Staff may provide any nursing services permitted under the facility's license and total help with the activities of daily living for residents admitted to hospice. Staff may not exceed the scope of their professional licensure or training in any licensed assisted living facility. The facility must make available to potential residents a written statement or statements that include the following information listed on the next slides. Providing a copy of the facility resident contract or facility brochure containing all the required information. The facility's admission and continued residency criteria. The daily, weekly, or monthly charge to reside in the facility and the services, supplies, and accommodations provided by the facility for that rate. Personal care services that the facility is prepared to provide to residents and additional costs to the resident, if any. Nursing services that the facility is prepared to provide to residents and additional costs to the resident, if any. Food service and the ability of the facility to accommodate special diets. The availability of transportation and additional costs to the resident, if any. Any other special services that are provided by the facility and additional cost, if any. Social and leisure activities generally offered by the facility. Any services that the facility does not provide, but will arrange for the resident and additional cost, if any. The facility rules and regulations that resident must follow. The facility policy concerning do not resuscitate orders and advance directives. If the facility is licensed to provide extended congregate care, the facility residency criteria for residents receiving extended congregate care services, the facility must also provide a description of the additional personnel, supportive, and nursing services provided by the facility, including additional costs and any limitations on where extended congregate care residents may reside based on the policies and procedures. If the facility advertises that it provides special care for individuals with Alzheimer's disease and related disorders, a written description of those special services as required. The facility's resident elopement response policies and procedures. Before or at the time of admission, the resident or the resident's responsible party, guardian, or attorney in fact, if applicable, must be provided with the following: a copy of the resident's contract, a copy of the facility statement described in paragraph A of this subsection. if one has not already been provided. A copy of the resident's Bill of Rights. A long-term care ombudsman's program brochure that includes the telephone number and address of the district office. Documents required by this subsection must be in English. If the resident is not able to read or does not understand English and translated documents are not available, the facility must explain in its policies to a family member or a friend of the resident or another individual who can communicate the information to the resident. Upon admission to a long-term care facility, each resident or representative of a resident must receive information regarding A. The purpose of the state long-term care ombudsman's program, the statewide toll-free telephone number and email address for receiving complaints, and information that retaliatory action cannot be taken against a resident for presenting grievances or for exercising any other resident right. Each resident must have been examined by a licensed physician, a licensed physician assistant, or a licensed advanced practice registered nurse within 60 days before admission to the facility or within 30 days after admission to the facility. The information from the medical examination must be recorded on the practitioner's form or on a form adopted by the agency rule. The medical examination form signed only by the practitioner must be submitted to the owner or administrator of the facility, who shall use the information contained therein to assist in the determination of the appropriateness of the resident's admission to or continued residency in the facility. The medical examination form may only be used to record the practitioner's direct observation of the patient at the time of examination and must include the patient's medical history. Such form does not guarantee admission to, continued residency in, or the delivery of services at the facility and must be used only as an informative tool to assist in the determination of the appropriateness of the resident's admission to or continued residency in the facility. The medical examination form reflecting the resident's condition on the date of the examination is performed becomes a permanent part of the facility's record of the resident and must be made available to the agency during inspection or upon request. An assessment that has been completed through the Comprehensive Assessment and Review for Long-Term Care Services, also known as CARES, program fulfills the requirements for a medical examination. Any resident accepted in a facility placed by the Department of Children and Families must have been examined by medical personnel within 30 days before placement in the facility. The examination must include an assessment of the appropriateness of placement in a facility. The findings of this examination must be recorded on the examination form provided by the agency. The completed form must accompany the resident and be submitted to the facility owner or administrator. Additionally, in the case of a mental health resident, the Department of Children and Families must provide documentation that the individual has been assessed by a psychiatrist, clinical psychologist, clinical social worker, or a psychiatric nurse, or an individual who is supervised by one of these professionals and determined to be appropriate to reside in an assisted living facility. The documentation must be in the facility within 30 days after the mental health resident has been admitted to the facility. An evaluation completed upon discharge from a state mental hospital meets the requirements of the subsection related to appropriateness for placement as a mental health resident, provided that it was completed within 90 days prior to admission to the facility. The Department of Children and Families shall provide to the facility administrator any information about the resident which would help the administrator meet his or her responsibilities. Department of Children and Families personnel shall explain to the facility operator any special needs of the resident and advise the operator whom to call should problems arise. The Department of Children and Families shall advise and assist the facility administrator when the special needs of a resident who are recipients of an optional state supplementation require such assistance. As part of the admission criteria, an individual must undergo a face-to-face medical examination completed by a healthcare practitioner. A medical examination completed within 60 days before or within 30 days after the individual's admission to a facility. The physical and mental status of the resident, including the identification of any health-related problems and functional limitations. An evaluation of whether the individual will require supervision or assistance with the activities of daily living. Any nursing or therapy services required by the individual. Any special diet required by the individual. A list of current medications prescribed and whether the individual will require any assistance with the administration of medication. Whether the individual has signs or symptoms of tuberculosis, methicillin resistant, Staphylococcus aureus, scabies, or any other communicable diseases which are likely to be transmitted to other residents or staff to be transmitted to other residents or staff. A statement on the day of examination that In the opinion of the examination healthcare practitioner, the individual needs can be met in an assisted living facility, and the date of the examination and the name, signature, address, telephone number, and license number of the examining healthcare practitioner. When a healthcare practitioner conducts a medical examination, the examination must be recorded on the practitioner's form or on ACA's Form 1823, Resident Health Assessment for Assisted Living Facilities, April 2021, which is incorporated by reference and available online at the website provided below. Faxed or electronic copies of the completed form are acceptable. If ACA Form 1823 is used, the form must be completed as instructed. Make sure you remember that form. That is ACA Form 1823. It'll look something like this. I know it's not exactly clear, but this is ACA Form 1823. It'll basically tell you step by step what needs to be done as far as the paper being filled out. If the healthcare practitioner form does not include all the examination items on ACA Form 1823, or if ACA Form 1823 is not completed fully, then the omitted items may be obtained by the administrator or designee either orally or in writing from the healthcare practitioner. Sorry about that. The missing or omitted information must be obtained and documented in the resident's records within 30 days after the resident's admission to the facility. Omitted or missing information received orally must include the name of the healthcare practitioner, the name and signature of the administrator or designee recording the information, and the date the information was provided. Medical examinations of residents placed by the Department of Children and Families, or by the agency under contract with either department must be conducted within 30 days before placement in the facility and recorded on ACA Form 1823. An assessment that has been conducted through the Comprehensive Assessment, Review, and Evaluation for Long-Term Care Services, also known as the CARES program, may be substituted for the medical examination requirements. Any orders issued by the healthcare practitioner conducting the medical examination for medications, nursing services, treatments, therapy, or therapeutic diets may be attached to the health assessment. A healthcare practitioner may attach a DH Form 1896 Florida Do Not Resuscitate order form for residents who do not wish cardiopulmonary resuscitation to be administered in case of cardiac or respiratory arrest. A resident placed in a facility on temporary emergency basis by the Department of Children and Families is exempt from the examination requirements of this subsection for up to 30 days. However, a resident accepted for temporary emergency placement must be entered on the facility's admission and discharge log and counted in the facility census. A facility may not exceed its license capacity in order to accept such a resident, a medical examination must be conducted on a temporary emergency placement resident accepted for regular admission. Before receiving extended congregate care services, all persons, including residents transferring with the same facility to the portion of the facility licensed to provide extended congregate care services, also known as ECC, must be examined by a healthcare practitioner. A health assessment conducted no more than 60 days before receiving extended congregate care services meets the requirement. Once receiving services, a new health assessment must be obtained at least annually. Before the admission of an individual to a facility licensed to provide extended congregate care services, the individual must undergo a medical examination and the facility must develop a preliminary service plan for the individual. If a facility can no longer provide or arrange for services in accordance with the resident service plan and needs and the facility's policy, the facility must make arrangements for relocating. Appropriate of placements, examination of residents, continued residency. The owner or administrator of a facility is responsible for determining the appropriateness of admissions of an individual to the facility and for determining the continued appropriateness of residence of an individual in the facility. A determination must be based upon an evaluation of strengths, needs, and preferences of the resident, a medical examination, the care and services offered or arranged for by the facility in accordance with facility policy, and any limitations in law or rule related to admissions, criteria, or continued residency for the type of license held by the facility under this part. The following criteria apply to the determination of appropriateness for admissions and continued residency of an individual in a facility. A facility may admit or retain a resident who receives a health care service or treatment that is designed to be provided within a private residential setting if all requirements for providing that service or treatment are met by the facility or a third party. A facility may admit or retain a resident who requires the use of assistive devices. A facility may admit or retain an individual receiving hospice services if the arrangement is agreed to by the facility and the resident. Additional care is provided by a licensed hospice, and the resident is under the care of a physician who agrees that the physical needs of the resident can be met at the facility. The resident must have a plan of care which delineates how the facility and the hospice will meet the scheduled and unscheduled needs of the resident, including, if applicable, staffing for nursing care. Except for a resident who is receiving hospice services, a facility may not admit or retain a resident who is bedridden or who requires 24-hour nursing supervision. For purposes of this paragraph, the term bedridden means that a resident is confined to a bed because of the inability to move, turn, or reposition without total physical assistance. Transfer to a chair or wheelchair without total physical assistance, or sit safely in a chair or wheelchair without personal assistance or a physical restraint. A resident may continue to reside in a facility if, during residency, he or she is bedridden for no more than 7 consecutive days. If a facility is licensed to provide extended congregate care, a residency may continue to reside in a facility if, during residency, he or she is bedridden for no more than 14 consecutive days. A resident may not be moved from one facility to another without consultation with and agreement from the resident, or if applicable, the resident's representative or designee, or the resident's family, guardian, surrogate, or attorney in fact. In the case of a resident who has been placed by the Department of Children and Families, the administrator must notify the appropriate contact person in the applicable department. A physician, physician assistant, or advanced practice registered nurse who is employed by an assisted living facility to provide an initial examination for admission purposes may not have financial interest in the facility. As part of the continued residency criteria, a resident must have a face-to-face medical examination by a healthcare practitioner at least every 3 years after the initial assessment, or after a significant change, whichever comes first. The result of the examination must be recorded on the practitioner's form or on ACA's Form 1823. Exceptions to the requirement to meet the criteria for continued residencies are: the resident may be bedridden for no more than 7 consecutive days, unless the resident is receiving licensed hospice. A resident requiring care of a stage 2 pressure sore may be retained provided that the resident contracts directly with the licensed home health agency or a nurse to provide care, or the facility has limited nursing services license and services are provided pursuant to plan of care issued by a healthcare practitioner. The condition is documented in the resident's record, and if the resident's condition fails to improve within 30 days, as documented by a healthcare practitioner, the resident must be discharged from the facility. A terminally ill resident who no longer meets the criteria for continued residency may continue to reside in the facility if the following conditions are met. The resident qualifies for, is admitted to, and consents to receive services from a licensed hospice that coordinates and ensures the provision of any additional care and services that the resident may need. Both the resident or the resident's legal representative, if applicable, and the facility agree to continued residency. A licensed hospice is in consultation with the facility, develops and implements an interdisciplinary care plan that specifies the services being provided by hospice and those being provided by the facility. And documentation of these requirements of this paragraph is maintained in the residence file. The facility administrator is responsible for monitoring the continued appropriateness of placement of a resident in the facility at all times. A hospice resident that meets the qualifications of continued residency may only receive services from the assisted living facility staff which are within the scope of the facility's license. Assisted living facility staff may provide any nursing services permitted under the facility license and total help with the activities of daily living for residents admitted to hospice. However, staff may not exceed the scope of their professional license or training. Knowledge of the admission requirements for mental health residents. Have a copy of each mental health resident's community living support plan and the cooperative agreement with the mental health care services provider, or provide written evidence that a request for the community living support plan and the cooperative agreement was sent to the Medicaid managed care plan or managing entity under the contract with the Department of Children and Families within 72 hours after admission. The support plan and the agreement plan may be combined. Have documentation provided by the department that each mental health resident has been assessed and determined to be able to live in the community in an assisted living facility that has a limited mental health license, or provide written evidence that a request for documentation was sent to the department within 72 hours after admission. Make the community living support plan available for inspection by the resident's legal guardian or healthcare surrogate, and other individuals who have a lawful basis for reviewing this document. If the facility initiates an involuntary mental health examination, the facility must document the circumstances leading to the initiation of the examination. If the resident no longer meets the criteria for continued residency, or the facility is unable to meet the resident's needs as determined by the facility administrator or healthcare practitioner, the residents must be discharged. Closing of facility. Notice, penalty. The facility shall inform in writing the agency and each resident or the next of kin, legal representative, or agency acting on the resident's behalf of the fact and the proposed time of the discontinuance of operation. In the event a resident has no person to represent him or her, the facility shall be responsible for the referral to an appropriate social service agency for placement. Immediately upon the notice by the agency of the voluntary or involuntary termination of such operation, the agency shall inform the state long-term care ombudsman program and monitor the transfer of residents to other facilities and ensure the residents' rights are being protected. The agency, in consultation with the Department of Children and Families, shall specify procedures for ensuring that all residents who receive services are appropriately relocated. All charges shall be prorated as the date on which the facility discontinues operation. And if any payments have been made in advance, the payments for services not received shall be refunded to the resident or the resident's guardian within 10 working days of voluntary or involuntary closure of the facility, whether or not such refund is requested by the resident or guardian. Get that money back. All right, so this is an important slide. $5,000 giveaway ain't a good thing because it might come from your pockets. Let's see what we got to say. The agency may levy a fine in an amount no greater than $5,000 upon each person or business entity that owns any interest in a facility that terminates operation without providing notice to the agency and the residents of the facility at least 30 days before operation ceases. This fine should not be levied against any facility involuntarily closed at the initiation of the agency. The agency shall use the proceeds of the fines to operate the facility until all residents of the facility are relocated. So basically what's happening is you're going to pay the agency $5,000 because you're being shut down, and they're going to take care of the residents that you do have with that $5,000 until they're relocated, pretty much. It's not a good thing.